Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam. My name is John Roberti. I will be your host today, and today's topic is what changes across the northern border? 5 key differences between U.S. and Canadian competition law. As we practice law, what we find is a tremendous amount of cooperation between U.S. practitioners and Canadian practitioners. As we practice in the United States, it's very practical. Canada is closest to us geographically, along with Mexico, of course, and we find ourselves culturally aligned, and in many businesses doing business across borders. So there's a lot that we have in common. What we wanted to explore today is what are the key differences, and where do they come up, and how does that affect our practice? My co-host today is Christina Ma. Hi, Christina.
Thanks, John. Hey, John.
So, Christina, what are we doing today?
We are speaking to Huy Do, who's a partner at Fasken in the Antitrust and Competition Law section. He's also the chair of the Competition Law section of the Canadian Bar Association. And he's here to tell us a little bit more about Canadian competition law and how it differs from U.S. competition law.
And why is this important?
John, as you mentioned, there are a lot of instances in which matters cross borders, whether they be criminal or civil or merger matters. And it's important to understand how different enforcement regimes might impact both the work of clients and also government officials in their work as well.
All right. And what are we hoping to get out of today's program?
I'm hoping, and hopefully our guests are hoping, to learn a little bit more about our friends up north and the laws that regulate the industries there and how that compares to our U.S. practice.
Great. All right. Well, let's bring our guest. Huy Do, welcome to the program.
Thank you, John. Thank you, Christina.
So, Huy, thank you for joining us today. I am told that you have identified 5 of the key differences between U.S. and Canadian competition law. So maybe we'll just kick it off with the first one. Sure.
Well, thanks for having me, first of all. And second of all, John is right in the sense that our antitrust or competition law, as we call it here in Canada, have been converging more recently. Our history has not always been that way. There have been instances where I guess the antitrust policies north and south of the border have varied significantly. In the 70s, in particular, when you have the uranium cartels, where I think the governments found themselves on different sides of the antitrust issues. But I think, notwithstanding that Canada, we always brag that we had the first antitrust law. Ours came into force a year before your Sherman Act, but we've been playing catch up ever since. So I think more recently, I think our laws in this area have tended to converge, which is, I think, a good thing from a business standpoint. It makes business transactions and conduct a lot easier to manage and for businesses to comply. That said, there are some significant differences, and I think we'll walk through the 5 of them. But the first one, I think, it's a bit, I guess, it's good for Canadian competition lawyers because I think we have a bit more simpler legislative and enforcement regime than you do in the U.S. I think every time I see the U.S. Antitrust law scattered through all your different statutes and the myriad of enforcers, you have 2 at the federal level, and then you have all the state attorney generals and so forth. It can be quite daunting. I mean, in Canada, we have essentially one statute, and although we're both common law jurisdictions, we don't have the richness of jurisprudence, case law jurisprudence in Canada as you do in the U.S. in the antitrust field. So we have one statute that tends to be fairly well defined in terms of the rules. So a lot of our rules are codified as opposed to being found in cases. So that's one easier thing for us to do in Canada.
So, it's funny that you say that, because I often tell people you make a good point about the various states, and that adds a whole level of complexity. But often what I tell clients is that, the Sherman Act is actually really pretty simple. It's basically 2 sentences that tells you what you can't do. I guess the complexity is that we don't have rules, and everything gets developed on the fly through case law and through interpretation. Is there? I see some cases in Canada, but I guess there's less of that.
There's less case law for sure, and that's one of the reasons why I think when the statutes were amended here in Canada, I think we modernized our Competition Act, and one of the reasons why that was a big thing was because we didn't have the cases that created some of the rules we have in the U.S. Right? The per se rules versus the rule of reason. We never had that. We had a very general statute, and then for cartels, for the longest time, we had a cartel provision that did not have a per se class of offenses. So it made things very difficult. So as a result, I think our parliament decided that when there was time to update and modernize our statutes, I think some of the rules that we have in the U.S. that have been derived from case law, we decided to codify. It's a little easier for us, I think, to navigate.
And do you feel that having everything under a single statute, everything under a single agency, the Competition Bureau, does it streamline or make more predictable, antitrust practice, so that when you see trends in cartel practice, that kind of transcends into the other areas? Or is the agency sort of split up across different missions such that you could still have divisive policies across missions?
I think it mitigates against that. I think we have probably an easier time kind of understanding our regulator than you would in the U.S. just because you have so many different agencies, different interests. I think the Competition Bureau, there is one head of the Bureau. There are different branches within the Bureau, but I think overall it's easier for us to navigate. The one exception will and I'll touch on this a little later, is in relation to our cartel enforcement, where we have a more complicated regime. We have a bifurcated enforcement regime when it comes to criminal offenses, and that's where the cartel provisions would kick in. I think in the U.S., you have the U.S. DOJ essentially responsible for both the investigation and prosecution of criminal offenses. In Canada, we have a system where the Competition Bureau is our competition police, if you will, and they do the investigation and make a recommendation at the end of the day whether criminal charges are laid and how the prosecution is run. That's done by the Public Prosecution Service of Canada. So there you have that bifurcation, which can sometimes lead to issues which we've seen in the past.
So that leaves open the question: how does the Queen fit into all of it?
I'm sorry?
How does the Queen fit into all of the enforcement?
Thankfully, the Queen doesn't really show up other than in the style of cause when it's the Crown versus whoever it is.
Great. Anything else on that, John, or shall we move to the second?
Yeah, let's keep going.
So the second one, at a very high level, I think I've come to realize in Canada we tend to accept, and this is to our detriment, I believe, less competition than in the U.S. We're not as zealous in terms of protecting competition, and there are policy reasons. I think that succeeding governments have looked at and said, in some cases, prioritize over competition. So a good example would be what we have is a regulated conduct defense. I think you have something similar in the U.S. under implied immunity, but regulated conduct defense really says that you can't really convict someone for an offense under the Competition Act if the conduct that they're engaging in is authorized or essentially regulated by another statute. And so we have a lot of industries in Canada that are shielded from competition law or certain aspects of competition law. We have universal healthcare, which I think is a good thing. But as a result, a lot of the healthcare services and products are regulated in terms of pricing and whatnot. So to the extent they're regulated, they fall outside of the scope of the Competition Act. Usually, I say usually because, as I'll touch on a little bit, there's recent cases that that suggests maybe the area of exemption or defense is narrower than otherwise thought. We also have supply management in Canada. It's declining. We used to have a lot more sectors, especially in the agricultural area, where we have supply management. We used to have the wheat board, which essentially allowed the producers of wheat to decide how wheat is marketed on a collective basis. That has been dismantled, but we still have supply management in respect of dairy, maple syrup, of all things. We also have it in poultry and eggs. So in those areas, the competition rules don't apply in the normal way. And I mentioned earlier that there's a recent case. The question becomes for us is whether this regulated conduct defense applies to exempt you from the Competition Act as a whole or only certain parts of the Competition Act. I think there's new case law that suggests maybe the regulated conduct defense only will exempt you from the criminal rules of the Competition Act, so the cartel provisions, and the civil provisions such as merger control or abuse of dominance, which is akin to your monopolization types of rules. Those types of provisions are still applicable. That remains to be seen whether or not our regulators going to take the case on that. I have my doubts, but at least the door is a little bit open.
Why do you
so let's unpack. So you just mentioned a lot of stuff. I'd like to unpack it a little. So I find this fascinating. So that there are the pharma industry you mentioned, the dairy industry, and other agricultural areas where they're just immune, more or less, from the competition laws. Are the agencies that regulate those industries looking at competition at all as a factor in their consideration, or are they just looking at other components of, well, potentially, consumer welfare, but maybe other things as well?
Yeah, and I think we have to be careful because not all those industries as a whole are exempt. There's certain conduct that's exempt. So if the conduct that they're engaging in is regulated, that arguably is exempt. But if for instance, and a good example would be in dairy, I think the dairy industry, the supply management works such that the producers, the milk producers, I think there is a marketing board that would essentially decide how the milk is marketed. But once you get past that, you get into the next layer where that milk is then sold to processors and sold to retailers. Those other down the chain types of activity aren't necessarily regulated, so they would still be subject to competition rules. But to your point though, where there is these marketing board types or supply management systems, they are self-regulated. So in those instances, I don't think competition law is something that the milk boards or the poultry boards they look at. So it's not.
When you say self-regulated, so these marketing boards that you mentioned, those are private boards. Those aren't government agencies, or
in some cases they are set up they're created by statute, but essentially they are comprised of producers, right, who elect members on the board.
And is it the agencies that regulate? I guess is it a defense that the industry has, or is it, say, the agency that regulates the pharma industry to say, on this case, the conduct is so egregious, we're going to allow the Competition Bureau to go after this type of conduct?
Well,
is it more about deference, or is it about sort of an actual defense that parties have?
It's a defense only with respect to their conduct, right? And so we have to be careful. You said the pharmaceutical industry. The pharmaceutical industry, I think, in Canada, is subject to competition rules. It's only where, for instance, if they're dealing with drug pricing that's regulated by statute, provincial statute, for instance, then the fact that they have the same price, because that price is kind of arrived at through negotiation with the province, then in that instance, then that conduct would be shielded. But the pharmaceutical industry itself is still subject to the competition.
Okay.
Would you think that the reason for this is because the industries that are being more regulated are viewed as more or less a right, or so important to the Canadian culture that they need to be protected. Pharmaceuticals, part of healthcare. I think the Canadian system, it's viewed as a right, whereas here it's viewed as more as a necessity, but not a right. We don't have universal health care. Likewise, wheat and other commodities. And maple syrup, I just think is probably goes to the core of the psyche of Canadians with the maple leaf, and I know you make good pancakes. So is that what's going on? Why do you think that is?
It's interesting because I think if you look at supply management, I think part of it is this notion that we want to be independent when it comes to our food supply. It's agriculture. We look at some of these things, dairy, wheat in the old days, and so forth. So I think that's part of it. That's something that we want to make sure that we're self-sufficient, and this allows for the protection of the producers. I'm not sure that idealism holds much anymore, but I think that was the original intent. And on healthcare, you're right. I think there is this notion that healthcare is something that really shouldn't be subject to market forces. People shouldn't be, their medical needs shouldn't be subjected to their ability to pay or market forces. So that's kind of the thinking and the exception.
What's next? What's the next big difference?
Well, the next big difference, actually still on that rule, would be the efficiency defense. And this ties a little bit in with what we talked about before in terms of us accepting less competition in Canada than what would otherwise be the case in the U.S. We have under our merger law a legal defense that will allow for the clearance of otherwise anti-competitive mergers. So if you have a merger that is determined to be anti-competitive, it can nevertheless be cleared, or it cannot be blocked if the parties can demonstrate that the efficiencies that are derived from that merger would be greater and would offset any anti-competitive effects. So in the U.S., I believe efficiencies are looked at as a factor in the overall assessment. It's not a complete defense, whereas in Canada, by statute, I think the statute sets it out very clearly that it is a legal defense. So we've had a number of cases litigated on this efficiencies defense, and I think the parties have always really won, where they can demonstrate. So go ahead.
Yeah, so in the U.S., as you mentioned, it is a factor that they consider in merger analysis. There's often a debate or discussion, at least, with staff as to whether the efficiencies should count. And they look at whether or not the efficiencies are merger specific and whether they're likely to pass through to consumers. Is that a similar standard in Canada, or are you guys looking at, total welfare, just consumer welfare? Is there the same test, in terms of having to show merger specificity?
Yeah. The pass-through rule doesn't really apply in our efficiencies analysis. We don't have to. I think, the cases that in Canada doesn't require you demonstrate that the efficiency savings would be passed on to consumers. I think by and large, I think we look at it on a total welfare basis, but there is jurisprudence that has suggested there may be other standards that can be applied. I think we've used the balancing weights kind of analysis in one instance, for instance, where I think the thinking was that $1 in the hands of a consumer is a little different than $1 in the hands of a producer. Generally, they're treated as equal, but in some instances, I think the cases suggest that you may be able to make that distinction. But I think generally our rules and the way the analysis is done in Canada, it's probably more lenient to the parties when it comes to the efficiencies.
And I believe this, you mentioned it's been litigated and was recently won. Was that the same? I recall reading in the news there was a case where it was allowed through in Canada, but then ultimately blocked in the U.S.
Yes, so that was a case that happened fairly recently, within the last a couple of years, where it was Superior and Connexus that were trying to merge, and it was a cross-border transaction. The Competition Bureau, I think, ultimately cleared the transaction. They found that the transaction was anti-competitive, but the Competition Bureau said that it didn't believe it had a choice because it was satisfied that the efficiencies defense would save the transaction. So they cleared on that basis, even though it was anti-competitive. I think it was maybe on the same day or the following day, the FTC came out and said they were going to challenge that transaction. The transaction ultimately died. I think just goes to show you that in most cases, where there are cross-border deals, the Canadian efficiencies defense doesn't really matter as much because the business imperative usually means that what happens in the U.S. dictates what happens on this side of the border in terms of the parties' conduct.
Yeah, and you could also see, multinational issues, obviously, with the sufficiencies defense, but also we were talking earlier about, various industries that are, or certain conduct in various industries that may be immune from, Competition Bureau enforcement, but they still may be subject to civil and criminal enforcement in the U.S. to the extent they have operations in the U.S.
That's right, and I think Canadian companies are very aware of the antitrust rules in the U.S. and I think at the end of the day they want to make sure that even though there are these differences, the way they behave will ensure compliance on both sides.
Okay, great.
So what's the next one?
The next one is private enforcement. So in the U.S., I think private enforcement of antitrust law is huge business. I think there's class action in the cartel space. You see some in the with respect to monopolization, not as much, and then you see that type of private enforcement flourishing in the U.S. In Canada, we have very limited private enforcement when it comes to antitrust rules. So we do have private enforcement in terms of class actions to recover damages in relation to cartel conduct, which is similar to the U.S., except that in the U.S., the treble damages that's available creates a huge incentive. In Canada, I think the plaintiffs can only seek single damages. So although it's available there, it's a bit more circumscribed in terms of the damages. And essentially, that's kind of our private enforcement when it comes to antitrust. When it comes to mergers, there's no ability for private parties to seek to enjoin or otherwise challenge mergers. With respect to monopolization types issues, such as abuse of dominance here in Canada, exclusive dealing, that kind of conduct, there's very little private enforcement because the Competition Bureau tends to be the gatekeeper. Those types of conduct are challenged, if they are challenged, before the Competition Tribunal. And by and large, they're done by the Competition Bureau. In a very limited set of circumstances, private parties can try to bring an application to the Competition Tribunal to adjudicate these issues. But in those cases, they would have to get leave. And getting leave is fairly difficult. The bar that's been set is fairly high. And on top of that, the tribunal itself lacks the jurisdiction to award damages. So you can see the incentives for private enforcement when it comes to those types of issues are very, very limited. So in fact, we don't see very much of it. There has been this debate in Canada as to whether or not we, try to enlarge private enforcement, given that public enforcement is limited by the resources of the Competition Bureau.
So I actually am going to push back a little bit on this because I actually have a thesis that Canada has a very, very important role in the world when we think about private enforcement. I think this is one area where Canada is certainly diverging from the U.S. And I think as the rest of the world looks, the rest of the world may be thinking we don't want a system that looks exactly like the U.S. And really the most advanced private damages system for competition law outside of the U.S. is Canada. So I think you might see more and more countries in Europe adopting the Canadian system.
I agree that. I think on the cartel side, I think our class actions for single damages, I think is probably the right way to go in terms of the middle ground. I think the treble damages in the U.S., that creates a lot of incentives for gaming of the system and for strategic litigation as opposed to on the merits. So I think on that side, but when it comes to I think abuse of dominance, for instance, the fact that the Bureau is the gatekeeper is a good thing because it makes sure there is some check to the litigation. It's not going off the rails in terms of strategic litigation, but at the same time, the Competition Bureau, I think, will admit their resources are limited, and their ability to take on some of these cases is not infinite. And there may be instances where conduct that could or should be challenged are unable to or not brought before the tribunal. So there is, I think, that's where I think we're finding a little more tension on the civil review matters side of things, as we call it here in Canada, consumer monopolization. I think on the cartel side, I think that the class action system we have here in Canada with single damages, I think probably is the middle ground. I'm not sure where we'll end up on the others, but there is a heightened understanding that our Competition Bureau, although they try very hard to go after all these conduct, their resources are limited, and I think their ability to go after every conduct that's objectionable is going to be very limited.
Great. Now I think we may be on number 5. Am I right?
I think we are on number 5, and that takes us back. It circles us back to the cartel enforcement piece that I talked to you earlier about the bifurcation of our criminal enforcement, where we have the Competition Bureau driving the bus for the first leg of the journey and then essentially handing it off to the Public Prosecution Service. We don't have that one-stop shopping like you have in the U.S., where the DOJ has carriage of the case from the beginning to the end. And that, I think, has led to some issues in terms of enforcement in Canada. We don't have the same level of prosecutions when it comes to the criminal side of things as you do in the U.S. I think the track record here in Canada by the Public Prosecution Service is fairly weak in terms of successful prosecutions. I think most of the cases that have been pled to have been as a result of our amnesty or our leniency program. I think that's where a lot of the cases come out. The litigated cases tend not to go so well, and in some cases, the Public Prosecution Service have declined to lay charges. So that's where I think there is a little bit of work that needs to be done to try and get those two agencies on our side of the border kind of working better together. They have different mandates, of course, but I think that's where I think I've heard that there are those who would consider looking at a U.S. Style in terms of having one agency deal with both the investigation and prosecution. That said, I think there are proponents of our system which says that it's good that the prosecutor is independent. They'll have a fresh set of eyes. They'll look at the evidence and decide whether or not it's something that merits going forward. So that does play out.
I was going to ask, it sounds like the Public Prosecution Office has the ultimate say in prosecutorial discretion as to whether they bring the charges. Is there a view of, what percentage of cases are recommended for prosecution that ultimately result in charges being made?
I don't think those stats are public, but at least just based on my own experience, there aren't that many cases like currently with the Bureau, but I think it's probably a small number where the charges are not laid. There's also a small number of cases, and one in particular jumps out because it was fairly publicized around the world, where the charges were initially laid by the Public Prosecution Service and then subsequently withdrawn. And that was in relation to the domestic chocolate cartel in Canada. So it was one of those cases where we had an immunity applicant and we had a leniency applicant. So the second party agreed to plead guilty. I think they paid a fine of $4 million. And everyone else, I think, got charged because they didn't come in to cooperate with the Competition Bureau and the Public Prosecution Service. The charges were laid. Ultimately, however, the Public Prosecution Service decided to stay the charges. So they didn't proceed with that case. So you ended up with the perverse result that the only party that paid any type of penalty was the second in.
Right. Was the lenient. So yeah, interesting. So in terms of the leniency program, and also it sounds like maybe even settlements, that's all done by the Competition Bureau. Is that accurate? So there may be actually a higher incentive to I don't know, a higher incentive to settle or a higher incentive to hope that the prosecution office doesn't bring charges.
Well, in Canada, I think the carrot in terms of our own immunity and leniency program, they're modeled on the U.S. program. I think we borrow from U.S. DOJ's program, but it's a little different, and I think we have more incentives, to be honest, in terms of coming in. because the first party that comes in gets immunity for itself and its employees and directors and so forth. The second party in, I think in the U.S., their employees can be carved out, so they're not going to be immunized. In Canada, the second party that comes in, I think if they are going to cooperate and they qualify, their employees are also protected against personal prosecution. So that's a big carrot. That said, I think the costs have been fairly significant in terms of trying to cooperate and help the Bureau with its investigation. I think we're seeing less and less of the second ins coming in Canada, and I suspect that overall internationally, I think we're seeing less markers being sought for cartel offenses, just because I think the businesses are coming to the realization that getting into these arrangements, and because there's so many of them around the world, means that you're getting married to the agencies, the regulators, for a lengthy period of time with extended costs.
This has been great, and I want to shift gears a little bit and ask you maybe some questions that are not maybe directly on the big five differences. One question I have for you is how is the Canadian Bar Association working with, cooperating with the American Bar Association? What sort of programs and exchanges are in place?
Yeah, that's a great question, and I'm very fortunate because I think when I took on the mantle as chair of the CBA competition law section, I inherited a very good relationship with the ABA antitrust section. I think this has been going on for decades. I mean, the two sections have been very close. We have an ABA liaison to our CBA, I think, who participates in our monthly executive meetings, and our past chair acts as the liaison to the ABA antitrust section. So we have that close relationship. We do a lot of CLE together because, as you said, these cross-border issues are often of interest to our mutual clients. So I think there's a lot of CLE that's done on a joint basis between, for instance, the merger committee of both the ABA antitrust section and competition law section here in Canada. The young lawyers on both sides are actually very active as well. They do a fair bit of CLE in terms of getting younger members up to speed on the basics in terms of the fundamentals of antitrust on both sides of the border. Our colleagues in the U.S. are very good at helping us out in terms of attending and being speakers at our conferences, and we try to do the same with the ABA conferences.
You guys are a lot nicer than we are. But before we, one more question on this. If you're a young lawyer, what's in it for that young lawyer to join the Canadian Bar Association by extension, the American Bar Association?
It broadens your horizon, really, I think, from my perspective, because I think a lot of times when we practice in a certain area, we get a little bit of tunnel vision. We see, if we're a merger lawyer, we deal with mergers all the time. If you're a cartel person, you deal with cartel issues. I think being part of the association gives you a broader perspective on the other areas of antitrust law that you may not always have a chance to deal with. And then if you can do that, it allows you to move up in the leadership. I think the same way in the U.S., and it allows you to kind of stay in touch with not only other practitioners, but also the regulators. And I think that's very important because I think the relationship you have with the regulators are very, very important here in Canada.
All right, last question before we get to our final segment. Tell us something that's unusual, unexpected, surprising about yourself that we wouldn't know if we only knew you professionally.
Professionally or personally?
Yeah, tell us something that's surprising about you personally that we wouldn't know if we only knew you professionally.
Okay. Well, I was very close to being an American as opposed to Canadian. So I'm from Vietnam originally. So in 1975, when the U.S. pulled out of Vietnam, I was about 7 at the time. I was 6 at the time. My dad, who was in the South Vietnamese military, he was an officer there. I think he was given visas for him and his family to be airlifted out of Saigon at the time, and go to the U.S. His mom was sick, so he decided not to go. So we ended up staying, and then we escaped by boat later on, and fled as the boat people, the refugees, and ended up in Canada as opposed to the U.S. So I was that close to becoming an American, but things work out one way or another. So.
And listen, there's some people who are ready to trade for you if you ever want to make that change. Let's go to our final segment, which we call the Curious Hat.
And now it's time for the Curious Hat.
Okay, in this segment we have a actual hat where we have actual questions that we pull those questions out of the actual hat. Because we're not together, we're speaking remotely today. I'm going to ask you to choose a number between 1 and 20. And I will ask you the question that corresponds with that number.
17.
Okay, number 17. Okay. If you had to describe yourself in 3 words, what would those 3 words be?
Adaptable. 1?
Adaptable, you said?
Yeah.
Yeah, okay, kind of like, okay, adaptable, I understand what that means.
Fun-loving, that's 2 words really, but...
but fun-loving, 1 word with a conjunction will allow that, okay.
Hyphenated.
And very lucky.
Very lucky is an adjective modified by an adverb, but again, we'll allow that. So why do you say very lucky?
Well, I think, having escaped by boat from Vietnam, and it took a lot of lucky circumstances to kind of get me to where I am today. And so I think my parents have always instilled that in me. They said, karma is something that really you should be aware of, and you should really appreciate the fortune that's been bestowed upon you. So I think that's one thing I've always kind of held pretty close, is that be thankful for the fortune that has occurred in my life.
I'm going to make another word, and it's a cultural stereotype, but because you're Canadian, it's also modest, because I think much more than luck, you've had amazing success, and what a great story. And that's the end of our program for today. Thanks again. We'll look for you next time on our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.